Good day. My name is Deanne Feltham-Scott, OSH Educational Consultant in Prevention Services at Workplace NL. Welcome today to Marcia Thistle, Team Lead in Claim Services, as well as Dana Smith, Manager in Claim Services. This presentation is a recording from our Health and Safety Learning Symposium for 2023. The topic today is returning to work after a traumatic mental stress injury. At any point during this recording, please feel free to change your posture and just to do some light, gentle movements and stretching, just to ensure that you keep your musculoskeletal health, in check. So this session today will cover the reporting process, the adjudication process, legislative and policy changes, as well as return to work. So let's just begin by defining what a psychologically healthy and safe workplace looks like. It's one that actively promotes and protects the mental health of employees and keeps them safe, engaged, as well as productive. So generally, an individual is responsible for their own health and well-being, whether we're inside or outside the workplace. However, employers are responsible to protect the health and safety of workers while we are in the workplace, and that includes their psychological health and safety. However, trauma can happen on the job, and when it does happen, it's important that we have an effective, efficient claims process that helps to return workers to the workplace as early and safely as possible. So now I'm going to turn the rest of the presentation over to Marcia. Marcia will continue for the next few slides, and then we'll end with Dana Smith. Okay, take it away, Marcia.
Thank you, Deanne. First, I'm just going to bring you through the reporting process for a traumatic mental stress injury. Filing a claim is the same as it is for any physical injury claim. The same injury reporting forms are used, and a claim is opened at Workplace NL once either of these forms are received. Most of you may be familiar with the forms listed here. So we have the Form 6, which is the Worker's Report of Injury. That's basically your application form. Form 7 is the Employer's Report of Injury. A claim is also opened if a medical report is received from a treating healthcare provider. So once the claim is opened, a claims registration clerk will gather the remaining injury reporting forms, and you may receive a phone call requesting any missing information. So once it's all gathered, the claim is then released to the entitlement department for review and adjudication. Next slide there, Deanne. Before we move into reviewing the steps an intake adjudicator will take during the claim review process, I just wanted to take a few minutes to share with you some of the more recent legislative and policy changes relating to traumatic mental stress. As you will see, there are different effective dates for these recent changes, and it is a key part of the adjudication process. So the policy that is used is policy EN 18 called traumatic mental stress. That's the main entitlement policy used by the intake adjudicators when reviewing a claim submitted for mental stress. This policy came into effect in 1999, and under this policy, coverage for mental stress injuries was initially limited. At that time, the definition of injury under the Act indicated an injury did not include stress other than stress that was an acute reaction to a sudden and unexpected traumatic event. So if you think about that for a minute, it had to be an acute reaction. So it had to develop within days or weeks of the exposure. And I think we can all generally agree that not all stress reactions develop that quickly. In addition, it had to be a reaction to a sudden and unexpected traumatic event. So if you consider, for example, a first responder, it is an expected part of their occupation to respond to calls for assistance from the general public, for example, a fatal motor vehicle accident. So while they did respond to a traumatic event, the claim generally would have been denied as this was an inherent risk or an expected part of their occupation. So when the policy was amended on March 8th of 2018, the scope of coverage for traumatic mental stress was expanded. And this slide here just highlights some of the changes. So the definition of traumatic event was revised to remove the requirement for the event to be horrific. Cumulative effect was added to recognize that some workers may be exposed to multiple traumatic events over a period of time. And a final reaction to a series of traumatic events is considered to be the cumulative effect. If the worker does not show the effects until the most recent event, entitlement may be accepted even if it's not the most traumatic event. The requirement for an acute reaction to manifest within days or weeks of the exposure was removed. They eliminated the requirement for a traumatic event to be uncommon with respect to the inherent risks of the occupation. So that opened it up and included people such as first responders. A new section was also added on diagnostic requirements. So in order for a claim to be accepted, there must be a diagnosis as described in the most recent Diagnostic and Statistical Manual of Mental Disorders, and that's shortened to DSM. So that's published by the American Psychiatric Association. So it includes, but's not limited to, acute stress disorder, post-traumatic stress disorder, adjustment disorder, or anxiety or depressive disorder. And the diagnosis can be provided by a nurse practitioner, a physician, psychologist, or psychiatrist. So there was a lot of changes that took place when the policy was amended in 2018. Next slide, thank you. Then we fast forward to July of 2019. There were some legislative changes introduced at that time. That was when the presumptive post-traumatic stress disorder legislation was introduced for all workers. In part, the new clause states, where a worker is exposed to a traumatic event or events in the course of their employment, and they are diagnosed with PTSD by a psychiatrist or a registered psychologist, the PTSD shall be presumed, unless the contrary is shown, to be an injury that arose out of and in the course of the worker's employment. At that time, they also updated the definition of injury. So it was updated to be an injury does not include stress other than stress that is a reaction to a traumatic event or events. So they removed the requirement for it to be an acute reaction to a sudden and unexpected traumatic event as it was previously. And this new legislative change was applicable to all workers, not just particular occupations. It was all workers, and this was consistent with 3 other provinces, which are PEI, Manitoba, and Saskatchewan. So now that we've touched on some of the recent changes to legislation and policy, we're going to look at some of the steps an adjudicator takes when reviewing a claim that's submitted for traumatic mental stress. The first part is to consider whether the claim meets the criteria outlined in the presumptive PTSD legislation. In order to do that, they first need to gather some information from the workplace parties. So they'll complete an initial review within 48 hours, and this may include conversations with the worker and or the employer to gather information about the incident that occurred. If enough information has been provided with the application form, the adjudicator may just verify the incidents with the employer instead of asking the worker to recount the details, as this may be difficult for them. But in any case, the employer must confirm the incident that's being reported. The adjudicator also needs to determine if the incident or incidents meet the criteria of a traumatic event. A traumatic event may be the result of witnessing or being the victim of a criminal act or a horrific accident. They may have elements of actual or potential violence. And we're going to talk about some examples in a few minutes. They'll also review the medical information on file to determine if additional information is required. For example, they may be missing medical reports to confirm a diagnosis. Medical information is usually limited at this point in time. If they've been seeing a counselor or psychologist, those reports may need to be requested as well. So once they gather all that information, the first step is to determine, do they meet the criteria outlined in the presumptive PTSD legislation that came into effect in July 2019? So just back up a slide there. There you go. So the first thing is we have to look at the date of the event. So did it occur on or after July 1st of 2019? Do they have a PTSD diagnosis from a psychologist or a psychiatrist? And this has to be in accordance with the most recent DSM and have been made at least 30 days after the event. So that is one of the criteria to be diagnosed with PTSD, is the symptoms must be present for at least 1 month. If the claim meets these criteria, the claim is accepted and referred to a case manager. If the claim does not meet these criteria under the presumptive PTSD legislation, it's reviewed further to determine if it meets the criteria outlined under policy EN 18, traumatic mental stress. Next slide, thank you. So under policy EN 18, we review many of the same criteria we just mentioned. The event still has to meet the definition of a traumatic event as outlined in the policy, and the incidents have to be confirmed by the employer. A key part of the adjudication process is confirming when the traumatic event occurred, as this determines what policy is required to be reviewed. So as we just discussed, the recent policy change came into effect on March 8th of 2018. If the incident or incidents took place prior to March 8th of 2018, the old policy must be reviewed, as this is what was in place at the time the incident occurred. If the incidents took place on or after March 8th of 2018, the new policy is reviewed. So as we noted, coverage of mental stress injuries was limited under the old policy and excluded occupations with inherent risk, as the event had to be sudden and unexpected. So that's a key thing to keep in mind when those claims are being adjudicated. The policy still requires a diagnosis consistent with the DSM. That can include an acute stress disorder, PTSD, adjustment disorder, an anxiety or depressive disorder, just to name a few. And the difference under policy is that the diagnosis can be provided by a physician or a nurse practitioner in addition to a psychiatrist or a registered psychologist. This is just to provide some examples of traumatic events that are listed in the policy. It's not an exhaustive list by any means, but it gives an idea of the types of incidents that may meet the definition outlined. So witnessing a fatality, being the victim of an armed robbery, being involved in a hostage-taking incident, being subjected to physical violence, or receiving threats of physical violence where there is reason to believe the threat is serious. The policy also outlines some areas that are not considered traumatic and therefore do not meet the criteria to be accepted. So events that are not objectively traumatic for any person. So if the event is traumatic just to that individual due to a previous history or experience, that doesn't mean it's an acceptable claim. It has to be something that is objectively traumatic for any person. Stress that develops gradually over time due to general workplace conditions including exposure to work-related stressors that do not fit the definition of a traumatic event. These are not covered. Burnout from usual duties, workplace changes, performance demands, termination, demotion, discipline, work schedules, expectations, etc. These are not considered to meet the definition of a traumatic event and also are not covered. So once all the information has been gathered, the adjudicator determines whether the claim meets the criteria outlined in policy. So they have to confirm the traumatic event. They have to consider the applicable dates outlined in policy, whether it's before or after March 8th of 2018. They have to consider the DSM diagnosis being provided by one of the treating healthcare providers. So if the claim meets those criteria, it's accepted and it is referred on to a case manager. And that brings us to our next area, which Dana is going to cover about return to work.
Thank you, Marcia. So what's next? Once a claim is accepted for a traumatic mental stress injury, the claim is referred to the claims management area and assigned to a case manager. The initial contact with an injured worker is critical and sets the tone for all interactions on a go-forward basis. So establishing rapport and trust with the worker is key to a successful working relationship. Regular communication is also important, but how we communicate with the injured worker depends on the worker's diagnosis and their presenting symptoms. So, for example, the worker may need to have an authorized representative assist them in communicating with workplace personnel, and every claim circumstance is unique, and the case manager must be sensitive to that and adapt to the needs of the injured worker really throughout the whole claims process. The case manager will regularly monitor the claim and ensure the timely provision of healthcare benefits are being provided. And of course, return to work opportunities are regularly reviewed and explored when it's appropriate to do so. Work-related disability is often associated with many negative health and social outcomes. And that includes reduced quality of life associated with poor mental health, job loss, and of course, reduced lifetime income. Return to work is an important part of a worker's recovery. People are more likely to be sedentary when at home as compared to getting up and going to work each day. Movement, traveling to work, doing some light duty tasks, and the social aspect of work all help improve a worker's recovery. Meaningful work can add purpose and value to our daily lives and improve our outlook on life and keep us active and engaged in the workplace. Return to work also helps maintain experienced employees at the workplace, reduces turnover of staff and increases productivity, reduces claim cost, and return to work also maintains a worker's income while engaging in a planned recovery. So, does return to work look different for a traumatic mental stress injury? When planning for a return to work after a traumatic mental stress injury, the guiding principles are very similar as it would be for a physical injury claim. The focus of the plan should be on the functional abilities of the worker. However, every situation is unique, and depending on the worker's functional abilities, the work site, and the type of work being performed, a return to work can look different for each individual. A comprehensive return to work plan should involve the worker's union if applicable, the employer, all treating healthcare professionals, and the case manager. Every party should have a shared responsibility in the return to work plan. When discussing return to work, it's important to understand that the worker may feel worried about what other coworkers are thinking. feel shame, experience rejection, isolation, and/or experience stigma. During the planning stages, these concerns should be addressed upfront in a supportive manner. Otherwise, they may present as a barrier as the return to work plan progresses. Before I move on, I just wanted to take a few minutes to discuss an employer's duty to accommodate. All employers have a duty to accommodate to the point of undue hardship under the Human Rights Act. Undue hardship generally means that an employer must exhaust all reasonable means to try to accommodate an employee who has special needs and/or circumstances. Undue hardship is usually reached when an employer cannot sustain the financial or efficiency costs of the accommodation. So it's important to note that undue hardship will be different for each employer depending upon their own specific circumstances. The accommodation process is initiated if a worker cannot return to the essential duties of their position or suitable work. So in this case, a further accommodation must be explored, which may include looking at alternate work. Workplace NL can help clarify a worker's functional abilities information for return to work purposes, including when a traumatic mental stress injury has occurred. Your case manager and a return to work facilitator are available to provide assistance to you when at the accommodation stage of a claim. Please do not hesitate to call us if you need help. Some questions to consider when exploring a return to work can include, but are not limited to, what are the worker's functional abilities? What accommodation can help address or eliminate these limitations? In order to facilitate a successful return to work, what training, if any, should be provided to the leadership team, the supervisor, or other workers who work with the individual? Have all parties discussed the fears and concerns associated with the return to work plan? It may be necessary to provide some training for supervisors on how they can assist the worker when they return to work. Specifically, how to address the worker's limitations, help identify tasks which may be challenging for them, and how to evaluate the effectiveness of the interventions. On our website, on our My Workplace NL online services, there is an introduction to early and safe return to work training. This training is not specific to traumatic mental stress injuries, but may be helpful to you as you navigate early and safe return to work. A structured and coordinated return to work plan is critical, and having this in place optimizes and improves return to work outcomes. Involving the supervisor or the manager in the return to work process can help them feel more equipped to accommodate the worker when they come back to work. So what can accommodation look like? There is no comprehensive list of accommodations for people who are dealing with traumatic mental stress injuries. In some instances, a small employer will be unable to provide the same level of accommodation as a larger employer. However, in most cases, accommodation is inexpensive and mostly involves workplace flexibility and some creative thinking. Some common accommodations in the workplace may include flexible scheduling, which may include flexibility in the start or end of a workday or providing part-time shifts. Modifying job duties, which could include changing the job duties of the pre-injury position. Modifying the workspace or changing locations. So that could look like allowing an employee to relocate to a quieter area where they'll be free from distractions, or allowing an employee to work from home if it's available, or even work in another location. And then there's alternate duties, which could include duties that are not pre-injury duties within the worker's functional abilities. So alternate work could look like the worker doing a different job or bundling duties that are suitable to provide an accommodation to the worker. When return to work is being explored, a number of barriers may present themselves throughout the process. It's important to strive to create an atmosphere where employees are comfortable discussing issues that may affect them at work. It's important to approach return to work from a position of care and concern for the employee. This is more likely going to lead to a successful return to work and reduce mistrust on behalf of the worker. The plan must be clear, where all parties understand the limitations and abilities of the worker. Collaborate with the worker on any potential concerns and explore solutions. All parties need to be part of this process. Develop a clear written return to work plan. Employers and employees should work together to do this. If needed, occupational therapists and Workplace NL are here to help. Employers and employees should agree on who might need to know about the employee's condition and what information should be shared. Confidentiality and privacy should always be respected. Some final thoughts. As we continue to manage claims accepted for traumatic mental stress injuries, we have found that return to work outcomes are improved when employers have a workplace culture built on trust, honesty, and fairness. Ensure your team and workplace are educated on mental health concerns and receive training to smash stigma. Maintain contact with the worker, both at the time of injury and after a return to work. It's important for workers to feel valued and supported by their employer. Collaborate together to find solutions and address any barriers that arise immediately. Remember to capitalize on the worker's strengths and highlight how they add value to the team. And finally, monitor the plan as it's documented and regularly review to ensure the plan is effective. Don't hesitate to reach out and ask for help if needed. If everyone works together, there's a greater chance for success, which benefits both the worker and the employer at the end of the day.
I'll take over now. Thank you very much. Thank you to Dana and to Marcia for joining us today to talk about this really important activity in the workplace in returning workers to the workplace after they have been diagnosed with a traumatic mental stress injury. We will not be taking any questions during this recording. However, if you do have any questions, please forward them on to workshops@workplacenl.ca. And your feedback is important to us as well. Please send that feedback to us in the email at the email address that I just gave you. And to repeat that one again, workshops@workplacenl.ca. Thank you and have a